One of the most debated agreements concluded by the European Union with a third country over last year is the association agreement with Ukraine. It is called AAU, and the AAU was signed in 2014. It entered into force 3 years later, but already in 2016 the parties decided to grant it provisional application, at least in part. The AAU is an associated agreement, thereby based on Article 217 TFEU, which, however, contains most of the peculiar aspects of new generation free trade agreements. In particular, the AAU establishes a deep and comprehensive free trade area, namely an advanced form of cooperation leading to a strong integration of the third country concerned in the EU internal market. It means that typical freedoms of the EU internal market are basically extended to Ukraine, which is probably the most integrated of the associated countries. And the AAU also has peculiar aspects because being an associated agreement, the core of this instrument apparently is not represented by trade-related aspects only, as it can also be inferred by the objectives listed in Article 1. For example, the parties committed to enhancing cooperation in the field of environmental protection and with regard to the principle of sustainable development and also to the green economy. There is also a chapter seeking to reconcile sustainable development and trade interests. It is chapter 13, which is composed of 14 articles. However, trade-related concerns play a very important role, and above all, as a general rule, the AAU prohibits restrictions to importations and exportations and stresses the link between the AAU itself and GATT under this point of view. So, to this end, Article 11 of the GATT Agreement of 1994 and its interpretative notes are incorporated into and made an integral part of the AAU. Furthermore, nothing in the AAU shall be construed in such a way as to prevent the adoption or enforcement by any party of measures in accordance with Articles 20 and 21 of GATT and its interpretative notes. So, when assessing the AAU, it is of utmost importance to consider Articles 11, 20 and 21 of GATT. Article 11 is about the general elimination of quantitative restrictions, while Article 20 lays down some exceptions, provided that such measures are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail or a disguised restriction on international trade. Conversely, Article 21 contains a clause for the safeguard of essential security interests for any party vis-à-vis trade liberalization. So, the dispute between the European Union and Ukraine revolves around Article 35 of the AAE, which states that no party shall adopt or maintain any prohibition or restriction or any measure having an equivalent effect on the import of any good of the other party or on the export or sale for export of any good destined for the territory of the other party. The baseline issue is represented by a measure adopted in 2015 by Ukraine. According to this measure, Ukraine decided to adopt, to restrict exports of certain types of goods to the European Union. And given the high volume of the wood importation for the European Union from Ukraine, this measure apparently constituted a problem that was immediately traced back to Article 35 AAE. And in sum, the implementation of the AAU experienced the long-lasting tension between trade-related interests and environmental concerns. So as the parties failed to resolve the dispute by recourse to consultations as provided by Article 305 AAU, the European Union requested the establishment of an arbitration panel basing on Article 306 AAE, and the arbitration panel was asked to assess the compatibility of the measure concerned with the AAU, particular Article 35. But it is interesting to note the reaction of the European Parliament. Of course, the European Commission was in favor of the establishment of the panel. It goes without saying that this was a choice of the European Commission, but the European Parliament, contrary, expressed the need to safeguard environmental concerns also through measures like the one at stake. So basically, the European Parliament welcomed the measure that was adopted by Ukraine in 2015. So which could be the next possible scenarios? I think it is very important to stress the role played by the key GATT. Environmental concerns are not openly mentioned in the exceptions set forth by GATT, which rather includes measures to protect human, animal or plant life on Earth and measures relating to the conservation of exhaustible natural resources. And when a state invokes exceptions under the GATT, it has the burden of proving the risk basing on scientific data and the necessity and proportionality of the measure concerned. Anyway, the incorporation of the AAU in the GATT framework suggests that the obligations of the former will tend to be interpreted in the light of the pro-trade dimension of the latter. Also, sanitary and phytosanitary measures of Chapter 4 of the AAU could be invoked. And in this case, it could be important to consider the WTO agreement on the application of sanitary and phytosanitary measures, the SPS agreement, in particular Article 5. However, should this be the case, the arbitration panel shall not decide the question, but it shall request the Court of Justice of the European Union to give a ruling on this specific question. Maybe the arbitration panel could provide an autonomous interpretation based on the Sustainable Development chapter, since the main issue is closely linked to sustainable development, but European Union primary law itself does not seem to provide for binding obligations construed to give priority to environmental concerns. Indeed, the nature of the principle of sustainable development, both at the international and at European level, is rather uncertain, and Article 37 of the Charter of Fundamental Rights concerning the protection of environment does not appear to enshrine a true fundamental right. And case law of the ECJ on the issue is rather poor. Maybe the panel could rely on the case law of the European Court of Justice concerning mandatory requirement, the environment as a mandatory requirement, and its reconciliation with Article 36 TFE.